Thank you all for coming. As you may know, this is our Sanfilippo Speak webinar series, which is our family support webinar series to provide families, caregivers, therapists, educators, clinicians, anyone in your life that helps with your child to get some helpful insights and discussions around any pivotal topics for navigating this life with Sanfilippo syndrome. So we really thank you for being here today and listening in for us. Today, our session is about estate planning. So we have Kellie Corbett here with us today, who is an attorney in Columbia, South Carolina. She has been practicing in the field of estate planning and elder law for over 8 years, and she loves it, which I have heard is kind of surprising in the field of law for someone to love estate planning. So we appreciate Kellie's expertise here today. Kellie is also no stranger to the personal importance of estate planning and special needs planning. She has a sibling with a rare neurodevelopmental condition as well. So we're going to touch on a little bit of that importance today. So Kellie, I will let you take it away.
Awesome. Well, thank you so much. I am really excited to be here and to talk to everyone about estate planning and in particular, some things you might want to consider when you have a beneficiary with any kind of special needs, but overall, how important estate planning is. So my plan for you guys today is to just kind of like set the foundation of what kind of documents are we talking about when we talk about estate planning? I am licensed in South Carolina and North Carolina, so I won't give anything too specific. I'll just keep it fairly broad for all of our other states that are represented here today. And then as Cassidy mentioned, I am happy to answer questions at the end. So anything that piques your interest or anything you'd like more information about. I plan to leave about 10 to 15 minutes at the end of our time today to get some answers to those. So I'm going to jump in and get started. If I can share my screen, we'll see. Okay, well, we are going to go ahead and get started. So when, again, we talk about estate planning, there's a certain continuum. This is what I typically use in my practice of kind of figuring out where you are on that continuum, what the future might hold for you. And we really want to plan for each part of like the life cycle for you. So sometimes we'll have just people that are in like the learning stage. Maybe they're growing their family, they're a younger family. They're more so focused on some of the basics and just getting educated. And then we'll have people in this kind of like optimizing or protecting phase. And that would typically be, you're well into your career, you're really saving for retirement, or you're right at that kind of pre-retirement age and thinking about, how to stretch your money over the retirement phase you're going to be in. And then certainly, I work in the elder law and elder care space. So that means we work with a lot of older clients who are in that maybe assisted or dependent kind of living level of the life continuum, meaning they're starting to have more care needs. They may be starting to consider moving out of their home into some type of facility or community. And we kind of help them with that transition as well. And just so you get an idea, this will start to make a little more sense, the life care pyramid here as we go through. People who are in the learning and growing phase might be fine with just more of like a basic essentials type of plan. When you're looking more at like the optimization phase, or again, thinking more about retirement, you might be looking at more of like trust planning or doing some care planning, like prevention planning for you. And then as you move into more care needs, that's when we kind of have our full life care plan in effect. So we'll kind of go through these different options today as well. Okay, so to just set the foundation a little bit more, like what is estate planning? Why does it even matter? Why do I need to do these things? So we see a lot of good, bad, and ugly in our line of work here. So when you get your full comprehensive estate plan in place, I cannot tell you how many people leave my office and they just have like a weight off their shoulders. They breathe the sigh of relief. They have a lot of peace of mind that they have a plan in place for all of kind of the what ifs that life might throw at them, and they feel a lot better about that. You can also ensure that you are protecting the assets that you've built up, you're protecting your loved ones, you have the proper provisions in place that they need at any given time. Every family is very, very different. So, if I have a family come in and they have three responsible adult kids, they've got a house, a car, and a bank account, they will have a completely different plan, completely different goals than a family who comes in, married couple, could be a blended family. There's young kids, there's kids with special needs, and they have a business. I mean, that's just, they have completely different goals in mind. So we want to make sure your plan protects you and your family the way you need it to. Anytime you do some proactive planning, you're probably going to cut out a whole lot of unnecessary expenses, unnecessary court involvement, overall make the process a little bit easier on your loved ones. And planning is not just about what happens when you pass away. I'll have a lot of people come to the office and we sit down and we're kind of designing their plan. And they say, "Oh, I already know who's going to get my stuff when I'm gone." We will certainly talk about that. We will design your plan to account for that. But it's not just about that piece. It's about living well, quality of life, what you want to happen while you are still here, and what you kind of foresee for your family. And then if you don't have a plan, there's a plan in place for you and what happens to your stuff. It's through the state, it's through the probate court or surrogate court or family court, whatever it is in your particular state. They all have some different names. But the state will have a plan in place if you don't have a plan. So, who gets what? That's called intestacy. That's just a fancy way of saying you died with no will, no trust, no nothing. So, what should happen to your stuff? If you die with no plan, your family's probably going to go through this thing called the probate process. Again, that's just kind of your stuff working its way through the court system, which can be time consuming, can be pretty costly. And then having no plan, you really run a much higher risk of family conflict and potentially unintended outcomes. So, for example, I hear quite a bit on kind of the back end of things, like after someone's passed away, um, "Hey, my mom always said I was going to get her house," or "My dad promised me that I was going to get all the money in his investment account." But if mom or dad didn't put some kind of actual plan in place to make sure that happens, lots of family conflict there, especially if someone feels shorted or feel like they didn't get what they were promised. And then unintended outcomes. As we go through today, you might start thinking about who you would name in some of the various roles or documents that we'll talk about. If you don't name them, though, and the court has the opportunity to put people in place, the court may not choose the same people you would have chosen because they're working with a different set of factors. They aren't working with any kind of background knowledge of your family, of the dynamics of the relationship. So, again, there's a plan in place if you don't have one, but it certainly may not be the one that you would have put in place for yourself. So, when we talk about comprehensive estate planning, which is what my firm and a lot of life care planning firms across the country will do, what legal documents are we actually talking about? Not that the plan is all about the documents and the pieces of paper in it, but just what is that so we have a good foundation. So, a couple things that are always going to come up and always going to be helpful. There is what's called a durable power of attorney or a financial power of attorney. Every state will have a little bit of a different naming convention for this. Sometimes just power of attorney, sometimes a general power of attorney. But this is the document that really says if I am too sick to make decisions for myself about my money, my assets, my accounts, my legal affairs, I am going to put an agent in place to make those decisions for me. So you have to also be really cognizant of who you're naming in this role because you really, really, really need to trust them implicitly. They are going to be handling your money, handling your legal affairs when you are not able to oversee them because you are too sick to make decisions for yourself. And one thing I get a lot, I won't even make anyone ask in the chat. Well, if I'm married, can't my spouse just do all of this for me? I don't really think I need a power of attorney. So certainly there are some things that your spouse would be able to do by virtue of being a co-owner on certain accounts. So I'm sure many of you who are married have a joint account with your spouse. So that means, sure, by virtue of being a joint owner, they could handle that account if you get sick. But if you have separate accounts, if you have separate assets, for instance, a retirement account like an IRA or a 401k, or maybe you have a car and it's just in one of your names because you're the primary driver. If they don't have some legal authority, like with a power of attorney, they don't have any way to act on your behalf as to that asset. So I've had people come in before and let's say, mom's not doing well and dad's like, hey, she hasn't been driving for many years. We need to sell her car. If her car is only titled in her name and there's no power of attorney in place, we are left going through what's called a guardianship or conservatorship proceeding, which I'll touch on a little bit more. Um, so the financial power of attorney is very important. And then a similar document, but just does something different, is a healthcare power of attorney, sometimes called a medical power of attorney or a proxy or something similar. Again, every state will have a little bit of a different naming convention. A healthcare power of attorney says, again, if I'm too sick to make decisions for myself, then here's who can make medical decisions for me. So if, for example, it's me. I'm in a car accident. I'm in a coma in the hospital. I cannot make decisions for myself. I cannot communicate them. My doctor will look at my healthcare power of attorney document and say, hey, who did you name to make decisions for you? Okay, you've got your mom listed first. I need to ask mom what type of treatment you would want. So again, it's really important that you name someone that you trust. And even more so in the medical side of things, I would say someone you trust to make the decisions you would make for yourself, not necessarily the decision that they would make for themselves or they would make for you. So anytime you have maybe a difference in kind of philosophy on medical decisions or potentially a different religious beliefs, you want to be really careful that you name, again, a person who will make decisions that you would want made for you, not just what they would do for themselves. There can be a difference there. And then relatedly, a living will. This can also be called an advance directive or an advance healthcare directive. A living will is a document that gives your healthcare power of attorney agent, like the person you named in that document, a little bit more guidance about what decisions you would make for yourself. So it will typically have a few different kind of end of life scenarios, and you will get to say whether you want treatment in those scenarios or not. So in South Carolina, for example, there will be a scenario of I'm in a coma and medically I will never come out of the coma. And so what would you want done in that scenario? Some people will say, please don't keep me alive artificially. Some people will say, please do everything you can to keep me alive. But without that document, your healthcare agent won't really know exactly what you want. So, healthcare power of attorney is naming a decision maker. A living will is giving that decision maker some guidance on what decision to make. And then a HIPAA authorization. I know everyone on this call has been to so many doctor's appointments. So, every time you go, you're signing off on paperwork, whether you kind of read through it all or not. A HIPAA authorization just says, hey, here are the people that you can share my medical information with. So you might choose to put people on your HIPAA authorization who may not be the right people to make a decision for you, because that would be on your healthcare power of attorney, but people you would want kept in the loop if something happened to you. So I see this used a good bit when maybe we have a spouse and maybe some older adult children named in the healthcare power of attorney, but there might be some younger children or close family members in the family who you'd want to be kept in the loop and get information if they want it. So they might be added on that HIPAA authorization. And then kind of a main vehicle for doing estate planning would be either a trust or a will. So again, since I can't see everyone, I won't make you raise your hands, but a trust is essentially like a banker's box. So hopefully everyone knows what that looks like, or a cardboard box if you want to use that visual. So a trust is something that, again, you put together typically while you're still living, you're alive and well, and you put a set of instructions on the front of that banker's box that says what to do in every scenario we could think of, who's in charge at different times, if you're sick, when you pass away, all of that. And you actually put your assets into that trust. So if you own your house, you'll take it out of your individual name, you'll put it in your trust name, and that means it's in your box. Bank accounts, stocks, bonds, brokerage accounts, vehicles, all of that kind of goes into the box. And then it's a fairly seamless transition when something happens to you. Again, whether you get too sick to make decisions or when you pass away. So in most states, that trust is going to avoid probate, which can be a very long, complicated process. At least it is in South Carolina and North Carolina. I won't speak to every other state, but generally, I get people coming in and saying, hey, I want things to be pretty easy on my family when I'm gone or when I get sick. So a trust is a way to have some good kind of planning measures for when you get sick, and again, avoids a court process when you pass away. If for some reason a trust doesn't make the most sense for you, or probate is not really a big concern or isn't very complicated in your state, you might end up with a will-based plan. And a will is fairly short and sweet and says, hey, when I pass away, here's the person called an executor, or sometimes called a personal representative. Here's the person who's in charge of all the stuff, all the assets I leave behind, and they should give these assets to the people I have listed. Those are your beneficiaries. And the will just works its way through whatever court process is in place at the time you pass away. That's called probate. So again, if I have families who come in and they say, hey, we've had a bad experience with probate, or we've heard it takes a long time, we want to avoid it, we would generally talk to them about a trust plan. Now, that being said, anyone who's done any kind of like internet research or has an estate plan already, there are lots and lots and lots of different types of trusts. So generally, these are the 3 or 4 that we talk about doing kind of typical estate planning and planning for beneficiaries with any kind of special needs. So if I have, for example, a married couple come in, they want to avoid probate when both of them are gone, then they might do what's called a revocable trust. So going back to my box example, that would be just like your banker's box with no lid on top. It's revocable. You can change it, you can amend it, you can take stuff in and out of it as you see fit. It's a really great probate avoidance tool. And then for some people, it might make more sense. Like if I have a 67-year-old come in, they don't have long-term care insurance. So they feel like they don't really have a way to pay for long-term care that they might need in the future. They want to protect their assets from Medicaid if they need long-term care in the future, but otherwise right now they're pretty healthy. They might put together what's called an irrevocable trust. So again, for all my visual people, if you're thinking about your box, this would be a banker's box that you put some stuff into and you put a lid on top of it. And that's kind of the irrevocable nature of it. You're not going to be making any changes to it. You're probably not going to be in control of that asset anymore. But in the longer term, you protect it from Medicaid or any other government benefit that would pay for long-term care. And then kind of what we're going to deep dive on a little bit today is a supplemental needs trust or a special needs trust. So I do hear people use those interchangeably, which I think is fine just when you're having like casual conversation. They are technically two different types, which we'll talk about in a minute. So a supplemental needs trust or a special needs trust is typically going to be used for some beneficiary. Doesn't necessarily have to be a child. I've seen grandparents put these together for grandchildren, aunts and uncles for nieces and nephews, but a trust for some beneficiary who receives some type of government benefit, and we don't want them to lose out on that benefit or lose that inherited money that they would get. And typically, this is going to be for what are called means tested benefits. That just means that the benefit is only available if you have below a certain income and or certain assets, some threshold there. So putting money into this type of trust is like another little closed box with a lid on top, and it's protected from that governmental entity coming in and taking it. Okay, but just to deep dive a little bit more, a special needs trust and a supplemental needs trust are ever so slightly different. So this may be more nuanced than you ever wanted, but we're going to kind of go through the differences between the two. So a special needs trust is very specifically a trust that's established for the benefit of a person who's receiving those means tested benefits of some kind. So I usually deal with Medicaid in my office, but it could be any kind of public benefit or someone who may need this in the future. So we will have families come in who certainly already have a beneficiary that's receiving Medicaid. We know we have to set this up for them. But we also have families come in and they're like, well, our child has some of these types of symptoms or issues right now. We don't know if they'll need benefits, but this might be the best way to set money up for them just in case. This type of trust is sometimes called a first party trust. And what that means is it's money that is the beneficiary's money. So typically, this would be, I'll give you guys an example. Again, I work with a lot of older clients in the elder care space. So this would be, let's say I have a client who comes in. She is already living in a nursing home. She's already receiving government benefits of some kind. And at the last nursing home she was at, she fell and worked its way through the court system. She's getting some kind of settlement money. So that money is hers. That is supposed to go into her pocket. That check would be cut to her. So we don't want her to lose out on benefits. We might use what's called this first party trust, put that money into this special needs trust. So it's not considered countable against her. And then the last kind of arrow on this slide, the thing that differentiates the special needs trust from the supplemental needs trust is a special needs trust having that first party money means that the state, whatever the state entity is, like here the Medicaid office is through DHHS. So the state has to be the primary beneficiary of that trust. So when the person passes away, the person who put their money in that box so they could continue receiving benefits, when they pass away, Medicaid or whatever government entity gets paid back first from any money that's left. So if Medicaid has paid out for this person $100,000 over, her stay at that nursing home, they get paid back first before any other beneficiaries after she has died. So that's one huge differentiation from the first party to the third party, which we're about to talk about. So first party is special needs trust, usually created from a settlement or inherited money, something that the beneficiary is receiving outright that would otherwise kick them off their benefits. Now, what most of you would probably be creating in your own estate plan for your own children or any beneficiary you know with special needs is a supplemental needs trust. So, biggest difference here is a supplemental needs trust is considered a third party trust. So, if you are a parent setting aside money for your child, that's third party money to that child. Like, it's not theirs, it's not something they earned, they haven't inherited yet, it doesn't come from a court settlement. That's what the third party means. So the supplemental needs trust, you have an option to create it now. Maybe if you have other family members who want to put money into it, you can kind of create that little box now and have people add to it. Or you can direct your executor to create it under your will after you're gone. But you have to make sure the provisions for creating it are in your will or your own trust before you die. You can't wait until after you're gone. And again, biggest differentiator here is that a supplemental needs trust does not require that the state be the primary beneficiary. So there's no payback provision there. So if you're a parent and you have a child with special needs and you say, hey, if I pass away before them, I want a third of my estate to go to them in a supplemental needs trust. When that child has passed away, that money, anything that's left, is going to go to kind of the backup beneficiaries that you named. So maybe your other children, maybe grandchildren, maybe niece and nephew, whomever. It does not go to pay back the state for what the state has paid out. So huge, differentiation there. So a special needs trust is for first party money, and there has to be a payback provision. A supplemental needs trust is for third party money, does not need a payback provision. Okay, so why might you use those? As we already talked about, you want to make sure if you have any individual as part of your estate plan who's receiving benefits, those means tested or needs based benefits, we want them to continue getting those benefits. We don't want them kicked off any program where they're receiving the medical care or the help that they need. It can also be good if you ever have a situation where maybe possibly the beneficiary that we're talking about isn't receiving benefits or may not need them, but they need to be protected or they need some assistance with managing that money. So I've certainly seen before we have families come in and they're like, our son is, he does pretty good. He goes to school, he graduated, he's not great with money. He may need benefits later. And gosh, he would give you the last $5 in his wallet if you so much as asked for it. So we're not necessarily saying he needs any means tested benefits right now. He may not need them in the future, but we're really worried that if he just had access to that money on his own, he could just give it all away. He's not good with handling money, or we just want some extra protections for him. Another option that I've seen some families use, and some of you might know about, other than the special needs trust or the supplemental needs trust, are those ABLE accounts. So an ABLE account is really good for a beneficiary who you want to give some autonomy to. Like, they're okay with money, they can have like a little debit card for the ABLE account. And as long as that ABLE account is below a certain threshold, it's not countable against them for any benefits they're receiving. So with the families I work with, I typically see when they have an ABLE account, it's generally like $15,000 or less in there. It can have more, but typically doesn't, again, just in my experience. And it's for a beneficiary who can handle that little bit of money. Or maybe they work a little bit, and so they have, they understand a little bit the value of a dollar, and we don't want them to have to ask their parents all the time for money. So they have that little bit in that account to use. And then the next biggest question I get is like, okay, Kellie, we kind of understand the difference between the two types of trust that we talked about, the special and the supplemental. Um, but gosh, we don't really want to restrict what our kids can use that money for, or the person in charge of that money. Like, how do they know what to do with it? It can actually cover so many things. So that could be things like any kind of medical expenses that maybe aren't covered by the benefits they're receiving. Again, working with like an older population. I had someone just a few weeks ago that we did this type of plan for, and he's like, hey, my insurance only covers me getting a pair of hearing aids once every 3 years, and I want 2 sets. So that would be something that isn't otherwise covered. It's a medical expense. The trustee gave him the money to pay for a second set of hearing aids. Any kind of special medical equipment, wheelchairs, specially equipped vehicles of any kind of therapy, rehab, education, travel for the beneficiary, whether that's vacation, visiting family. It can include the cost of like one person traveling with them if that's going to best support them being able to travel. Um, Recreation, entertainment. I have young kids I've worked with who have these types of trusts set up, and it's like, hey, they want to go to this summer camp this year for 2 weeks. Great, that's supporting them. Their insurance doesn't otherwise cover it. There's no benefit covering it for them. We'll use it. Legal expenses, any kind of final arrangements when the beneficiary passes away, and just general payments for any kind of companion or caregiver they have. So really think about like that term supplemental means, hey, we just want to supplement anything else they're already receiving. So use their full benefits first, make sure they're getting everything they can, but kind of anything else that they need, feel free to use this money for. So every family will look a little bit different with these. And you could restrict it a little bit more if you wanted to, but generally these are the things that I see come up. And then I always give it's better to be proactive than reactive. We help people in our office in both scenarios. Sometimes people are coming to us way in advance of anything happening, which is great. Sometimes people come to us kind of in the middle of something happening. And sometimes we'll get people come to us and say, hey, I should have done this 5 years ago, or my mom really needed care like yesterday, and now we've got to do something. So we'll help people in every scenario. It's just you have a lot more breathing room. You have a lot more options if you're not in a crisis and you've given this some like good thought before you ever utilize it. And especially for those of you, again, who are caretakers for any kind of beneficiary with special needs, always have a care plan in place and updated as much as possible. So Cassidy mentioned earlier that, we have a sibling who has some pretty severe special needs. It's really important for parents, especially, to have that care plan, kind of that continuity plan. Like, if something happens to me, here's how to care for this child, grandchild, this person in my household. Because you guys are the best source of knowledge on that and knowing what the day to day is for that beneficiary. So that's why I say at the beginning, it's not all about legal documents and it's not all about what happens with the money. You also want to ensure, again, like a good continuity of care. So what does the day-to-day look like? What are the doctors that this person sees? Who are some good contact people if something happens to me? I know that everyone likes to think, oh, well, nothing will happen to me. Everything will be okay. And that could be true, but we see in our line of work, anyone can get into a car accident. Anyone can kind of, gosh, have a heart attack, even if you're healthy. So having that plan in place is really crucial for your family and doing it in advance. If you try to do it in the middle of a crisis, it's going to be a lot more frustrating. It's going to be a lot scarier, and easier to miss things that you wouldn't have otherwise missed if you kind of had that advanced plan in place. And then one other piece I'll touch on, I did promise I would leave time for questions at the end. It is possible, for any of you who have minor children, know and have a plan for what happens when they turn 18. So at 18, whether you think so or not, child is considered a legal adult. So you may want to consider at least like 6 months before that point, would they need a guardian or a conservator appointed through the court? So what that means is a guardian is typically a person who handles kind of day-to-day and like medical decisions and care for someone. So in my family's situation, right, my brother has a guardian already. He's over the age of 18. He's not able to make decisions for himself. So our parents went through the guardianship process. And that's basically just saying this person who is now a legal adult is not competent, and that's the legal term for it, is not competent to make medical decisions on their own. We want the court to appoint a guardian for them. And then conservator or conservatorship is similar. Again, every state has a little bit of a different naming convention, but conservator is the person that would handle money for someone who is incompetent. So again, in our family situation, brother is not capable of handling money or handling finances or any income he receives. So a conservator is appointed solely to handle money on his behalf. So I've heard it in North Carolina, it's called guardianship of the estate and guardianship of the person. In South Carolina, guardianship is the medical piece, conservatorship is the money piece. Again, different states will have some different naming conventions, but it's something you can and should think about ahead of time for any minor children that you have. Hey, is this something that we're going to need to start once they're about 17 and a half or closer to 18 and get that court process rolling? And also consider who is the best backup guardian. I see this with a lot of parents. They say, oh, yeah, like, thank you so much for helping us through that guardianship proceeding. Like, we felt it went really smoothly. And then we ask them, like, yes, we got you appointed, which was fairly smooth. Who is a good backup for you? Because you got to get that care plan in place if you're the primary caretaker of this person who needs the guardian, but you also need to make a plan for if and when something happens to you, who would the backup guardian be? And you should be having a conversation with that person or those people, preferably not just kind of like naming someone you think will do it. Always good to have just, again, kind of a continuity plan in place. Okay, so I will open up for questions, but we do have a handy little quiz in my office for any of you who are South Carolina or North Carolina residents. The quiz kind of helps you just determine like what type of estate plan might be best for your needs, and what some considerations would be for that. So I will leave that up. Feel free to get that QR code and take the quiz. If you're not in North or South Carolina where we practice, might be able to still take the quiz and just get some considerations for what you may want to consider for your own estate plan in the state that you live in. I can only help put plans together for North and South Carolina residents. I don't want to lose my law license. Okay, what questions do I have?
So we do have a couple of questions, and I do want people to know if they are looking at this slide here, this
Yeah.
will be included in our Q&A companion document. So you don't have to worry about taking a screenshot or trying to remember the link information. We will include that as well after this is over.
Then I will
Um,
stop sharing and now I can see everyone.
Okay. All right. So we do have a couple questions from our chat, and then I came up with some while you were talking, to see if that might meet some of the needs that people might have. Okay.
Okay.
So our first question, is there an all-inclusive place where we can complete forms or tasks, or is all of this something that we would need to meet with a lawyer to do?
So there are some ways that you can get some pieces of this plan done. Most states will have a statutory form for like a healthcare power of attorney, maybe a financial power of attorney, although it'll typically be very basic. Um, Other than that, you're going to want to talk to a lawyer about it. I've seen way too many situations where people come in with a will or even a trust sometimes that they found online. And we look through it together and they aren't really sure what it says, or it doesn't meet their needs once I explain it to them. Or this actually happens a lot, they haven't actually signed it. So they'll bring it in and they're like, yeah, we have something, we feel good, and it's not signed, it's not been executed. So it's really just paper and they don't have any plan in place when they thought they did. So you'll definitely want to reach out to a lawyer and walk through your situation with them, and they'll be able to tell you, hey, here's a plan that best fits your needs.
Okay, so we have a specific situation here, but I think this can also apply to other families. This question is both of their children have Sanfilippo and likely won't make it into adulthood. And so if we have no supplemental trust, can the state come after us to recoup that money that they used while they're on Medicaid? But this family specifically currently has a revocable trust set up.
Okay, so answer would be no, because the kids are the ones receiving benefits, not the parents. I'm just making an assumption in this case. So the revocable trust that parents have, that's just like their money for benefits purposes. It's really no different than it being in their individual names. Medicaid can only recoup from what like the actual Medicaid recipient has. And I imagine since the kids are young, it's not like they've accrued assets that Medicaid would take back.
Okay, so then just to clarify overall, um, if a child were to pass, Medicaid is not recouping any money from a family with a child under 18.
No.
Okay. Okay. And then another question, and this one's a little bit more sensitive. Eh, would one of these trusts, a supplemental or a special needs trust, be recommended or a fit for planning and thinking about funeral costs for a special needs child?
Yeah, so this, keep in mind typically that supplemental needs trust, most of the time it gets created when like a parent has passed away. But one of the explicit expenses that can be used out of a supplemental needs trust or a special needs trust is for any final arrangements, final expenses, burial, cremation, etc. of the beneficiary. Yeah.
Okay. And then I have a couple more questions. So if you have any more questions or you want to ask any clarifying questions from those three, please feel free to put them in the chat while I have a couple more that I came up. So I think you kind of touched on the guardianship and the conservatorship. So thinking if I'm the sole guardian of someone and I have not appointed or thought about someone else to be a backup guardian, and this person may or may not be they're over the age of 18, of course, and I have a power of attorney. I get sick. How does my power of attorney or my guardianship then, how is that affected for my child?
Great question. So this would be, let me kind of walk through and make sure I'm using the correct terminology here. So if I'm just going to use like our family as an example. So if Cassidy is the legal guardian of Reed, our younger brother, and Cassidy, you're saying like you get sick, something happens with you, and you have a power of attorney because of course you do, which makes sense. So being appointed a guardian is through a court proceeding. A power of attorney is something you're able to put together legally on your own. So if you're the guardian for someone and you become too sick to serve in that guardian role, the court would appoint someone else. All that your power of attorney agent could do on your behalf is like put in your resignation as the guardian officially. Yeah. So it doesn't mean that whoever you, Cassidy, have named as your agent would then take over guardianship for younger brother. There would be like a separate court proceeding for that.
You also touched on, you have a family member who is not great with money? What if that family member also, you're kind of worried they may not be able to take care of themselves, but they're doing okay now, but you're not certain how that may progress or what may happen, and you don't have guardianship of them? How, what may happen if you don't have guardianship of that person?
So, first thing is like we always want to use like what's kind of the least restrictive method to get someone's affairs handled, right? So, as soon as your child or grandchild or whomever turns 18, if they really don't need a guardian, okay, there's lots of 18-year-olds that aren't great with money. Like that doesn't mean they need a guardian. So if they don't need a guardian, you can always reach out to an attorney to get them to put together their own power of attorney. So if they have the capacity, like the mental capacity, according to the legal professional they're seeing, that they can understand that power of attorney document, we can get them to sign one of those, appointing whoever they want as their agent to help them handle money. And there's other like practical kind of checks and balances you can put in place if they're okay with it. Some of you may have heard at a bank or really any financial institution, you can usually put in place what's called a trusted contact or trusted third party. So it's someone that says like, hey, if I, Kelly, am the owner of my bank account, but I feel like maybe sometimes I'm not great with money or I'm a little worried about my like mental capacity if I'm older, and I name my mom as my trusted contact, if I try to do any kind of transaction that's maybe over a certain amount of money, they'll kind of stop that from happening and they'll contact my trusted person first. So that can be one of those other, again, just like least restrictive methods. We never want to be overly restrictive, put someone under this guardianship when they just need a little bit of help with certain things.
So on a similar note then, how often would you revisit this? Like in Sanfilippo, sometimes the progression can vary by child. I mean, every child is different. So if your child is doing well now, but maybe you start to see some regression in skills, how often would you revisit these trusts in your will to make changes?
Yeah, so anytime that I have a family where yes, they might be doing well, but you know they have some kind of lifelong disease, something that's going to be there that probably means that they'll need government benefits. I would just say put at least some backup provisions in your will or your trust, regardless. You can talk to your attorney about leaving some flexibility in there, about kind of toggling it on or off depending on the situation when you pass away. Revisiting your plan, I usually tell people to at least look at their plan once a year, maybe 1 to 3 years. The more, and you're hitting on it exactly, like the more likely scenario that would necessitate changes to your plan is something happens with your family, not necessarily that there's some like big law change in estate planning, which honestly doesn't happen that frequently. So most of the time when families reach out to me for changes, it's because there's been a marriage, a divorce, a birth, a death, change in financial circumstances, something of that nature. Not that I reached out to them and said, oh, by the way, this power of attorney law has changed and you have to update X, Y, and Z.
Okay, so one more question so far. If any more come in, we'll cover those too, but I have one more question. So
Okay.
we talked about the executor. So
Yes.
if there is an emergency situation, how, first of all, how do you let that person know that they're executor and hand out copies to them? And then if there is an emergency situation, say that person is 2 hours away from you or you are on vacation and something happens, how does the hospital or any pertinent party know what your wishes are and who to contact on your behalf?
Yeah. So let's clarify a couple different like terms there because I have a different answer depending on which scenario we're talking about. So the most likely scenario that's truly an emergency is a healthcare scenario. There's really not a lot of financial emergencies that I know of. So I would always say once you have your healthcare power of attorney and any other ancillary healthcare documents set up, Definitely give a copy to every single person that you have named in that document, whether they're first or fifth on the list, doesn't matter. I would just give them a copy. I would keep a copy in your car. I would put a copy on file with your primary care physician and their group, like MyChart or Epic or whatever your system uses. And then other than that, I guess if you're going on vacation, you can always bring a copy with you. But as many people should know about the healthcare stuff as possible. So that's the only way I know how to do that part. And then keep in mind, the executor only comes into play if you have passed away and something needs to be filed with the court. Honestly, not an emergency. Like once you're gone and your will needs to be filed, we got to wait for a death certificate anyway. Probably not much of an emergency at that point. So for anything financial, again, feel free to give copies of your documents to whoever you want. Like I have families that share their whole plan with everyone they have named, especially my families with adult children. They'll say, hey, everyone has a copy of it. It's not like they can do anything with your will, until you're gone. And if you're worried that they're going to do something with your power of attorney, like with your assets or your money, while you still have the wherewithal to be overseeing them, probably not the right person to even name in that document. So I say to people, give copies of everything to the people you have named so they have them, and let them know where you are keeping the original documents so that if they need the originals for any reason, they know how to get to them.
Thank you so much, Kelly. Really appreciate your insight today with us. I have a couple of things I want to share with everyone before we go today. This is our general contact information. Our whole team has access to this, so we will get to you. And also my information, if you have any specific questions for me, there's my email and my cell phone number. Please don't hesitate to reach out to me. I also want to take a second to, let families know if you would like to share your child's story or share your family story. We do that through a network of partner families, and together we become less rare. So if want to get your child out there and share more about that, please feel free to reach out to us, and we can tell you more about how that process works. So that is all we have for you guys today. Thank you so much for sitting with us and listening to all of this. And if there are any further questions after we're done today, please feel free to email me, and we will see you all next time.